Well, hello and welcome to another episode by Financial Ernie. On today's episode, we're going to talk about Mullen Automotive and a lawsuit they have going on right now. It's a spoofing case, and there are some latest filings provided to the public on March 19th. So we're going to go ahead and break those down. Just to let you know, this will be a little bit of a lengthy video. I've got about 17 slides worth of content. The whole lawsuit or the new filing was over 70 pages long. There's also multiple exhibits that were provided as well. So let's go ahead and get right into it. So before we jump into the actual lawsuit, let's go ahead and break down who's actually involved. There were some new developments, some new people added to this case. Let's go ahead and take a look. So this plaintiff is Mullen Automotive Inc. as well, now added Hyan Cha and Cheyenne Korami. And if I'm mispronouncing those, sorry about that, folks. And defendants, we still have IMC Financial Markets, Clear Street Markets LLC, Clear Street LLC, UBS Securities LLC, and John Doe's 1 through 10. All right, so the filing starts out with an intro. So those of you who are not familiar with what spoofing actually is, let's go ahead and read along together a little bit. So this case involves spoofing, a form of market manipulation that defendants used to drive Mullen's share price downward between November 5th, 2021 and November 15th, 2023. So a little over 2 years is the relevant period for this specific lawsuit case. And as discussed in depth below, the defendant's spoofing schemes involved the strategic placement of cancellation of thousands of orders to sell on a NASDAQ limit order book. These orders to sell, commonly referred to as baiting orders, were not intended to be executed and had no legitimate economic purpose. So that is, by definition, what spoofing is, and Mullen and their attorneys are about to go into much detail as we continue on. So the defendant's spoofing schemes were executed through algorithmic trading programs that were utilized on high-frequency computer systems. It's important to define that because as we will continue to move forward and you'll learn more about this, these specific baiting orders were placed and canceled within seconds, not even seconds, within microseconds and nanoseconds of actually being placed. So let's go ahead and keep reading here. So the use of this highly sophisticated technology enabled the defendants and or customers to place and cancel thousands of baiting orders in a matter of milliseconds, repeatedly during a trading day and throughout a protracted trading period, thereby causing Mullen share price to remain artificially depressed. So it's really important that they set that up to let the potential judge know exactly what the spoofing claims are going to be and how they can define spoofing and how they can prove spoofing. So we're going to go into that again as we continue on. So during the relevant period, in reliance on the NASDAQ stock market being efficient and free from manipulation, Mullen sold over 5 billion shares, and the shareholders similarly sold shares at prices that were artificially depressed due to the defendant's unlawful spoofing schemes. It's important again that Mullen correlates this because yes, there were a lot of security purchase agreement warrants that were exercised during this period, but what's important to know is that if the spoofing, these baiting orders that artificially drove the price down, if those had any type of impact on Mullen's share price, then the exercise of those warrants by the different lenders, they're going to get them at the specific market price. If that market price is being reduced, that's going to create additional demand for more warrants, and we saw that as Mullen continued to have to provide additional supplemental prospectus filings, which means they gave more warrants to kind of compensate from the anti-dilution clause. So Mullen's going to go ahead and go into that a little bit further. So this lawsuit seeks to hold defendants primarily liable for their own unlawful principal in agency trading and knowingly, recklessly failing to fulfill their gatekeeping responsibilities of designing, monitoring, and enforcing a system of risk management and supervisory controls, policies and procedures that ensure that their traders and or customers complied with all applicable regulations and laws, including, and Mullen goes ahead and lists the actual laws that these market makers have to maintain, Section 9A and Section 10B of the Securities Exchange Act of 1934, and they go into the rules and the common law. So just in case you're still not quite familiar with how spoofing works, or in case the judge isn't quite familiar, the attorneys went ahead and gave a little bit more details in terms of spoofing. And again, they're going to use this information to kind of tie in how they can prove that these specific market makers were using this process. So in an efficient stock market that is free from manipulation, the prices of securities are determined by the natural forces of supply and demand. The greater the demand or lower the supply, the higher the price. Conversely, the lower the demand or greater the supply, the lower the price. The objective of a spoofing scheme is to distort publicly available information concerning the actual supply and demand of a company's securities by injecting false and misleading information into the marketplace. So if you are an investor and you're looking to purchase a specific security, whatever stock that may be, you're probably looking at that bid versus ask price, and you're probably trying to figure out, man, how can I get this thing at the right entry point, and then how can I get the right exit point? So if there are these artificial orders being placed and then canceled in terms of spoofing, that could actually change what the public is seeing in terms of the bid and the ask. So it's important that Mullen further defines that. Specifically, a spoofer often utilizing high-frequency trading computer programs that operate algorithmic trading programs to maximize the speed of their market access and execution of their trading strategies creates a false illusion of excess supply or demand by placing baiting orders into the limit order book. These baiting orders are not intended to be executed and have no legitimate economic purpose. That is bolded for emphasis because they are showing that this is a form of manipulation when the market makers place orders and they have no intention of filling those orders just to change the perception of the share price. That in itself is a form of manipulation. Instead, the baiting orders are placed solely to create the illusion of market interest, which is intended to generate a response from other market participants to follow the artificial selling or buying trend that the baiting orders were intended to create. So typically a trader buys when he or she thinks the price of a security is likely to go higher and sells when they think the price of the security will go lower. However, one of the clear signs of spoofing is a rapid reversal of trading direction. For example, where a market participant places many sell orders followed by a buy order followed by the cancellation of sell orders. This type of behavior strongly suggests that the original sell orders were not intended to be executed and instead were merely a ploy to drive the price downwards to buy low. So again, this is a way that these market makers are basically getting other people to purchase at these perceived bid prices, and then they're able to remove or cancel those specific bids. And then once the price is at a value that they want to enter at, then they'll enter at that. And that is spoofing and manipulation. So spoofing can be used to artificially inflate or lower the price of a security. If the spoofer's goal is to drive the price down, the spoofer enters baiting orders to sell, which are intended to bait or trick investors into entering their own sell orders to minimize or avoid suffering losses in a downward trending market. Shortly after the spoofers place the baiting orders to sell, and after those baiting orders have lured unsuspecting market participants into placing their own orders, the spoofer places orders to buy or executing purchases on the opposite side of the limit order book. These executing purchases to buy are intended to be executed at the artificially lower or low prices generated by the baiting orders to sell. Immediately after executing the purchases to buy in a limit book order, the spoofer cancels the baiting orders to sell or otherwise removes the supply of shares represented by the baiting orders to sell, completing the spoofing cycle. And a spoofing scheme, whether to drive the price upward or downward, is frequently used multiple times during a trading day and repeated throughout a protracted trading period. While each spoofing event may have limited impact on the market, and this is important, and I'll go into detail a little bit more, the cumulative and sustained effort of spoofing that occurs over a prolonged period can have a sustained negative impact on the price of the targeted security. So again, that little bit of information at the end is very important because this is part of the case. Although these specific baiting orders, this whole spoofing process may only show a very small amount of supply and demand changes, it does have a long-term impact on the price. And we will find out about more of that as we go along. It's actually part of the Exhibit 5. I'll give you a little sneak peek there. All right, this next little bit is going to be how Mullen's attorneys are setting up the future claims. So we'll go ahead and get right into this. So the defendant's unlawful spoofing scheme. So it's basically defining how they were doing these specific things. So each defendant has participated in spoofing schemes. It is difficult to identify manipulative schemes in listed securities like Mullen on the basis of publicly available data, because those who participate in market manipulation schemes often employ a variety of tactics to hide their unlawful conduct. And in most order flows in listed securities is publicly available only in anonymized form, which means you don't know who the buying or selling is. However, under the NASDAQ rules, registered NASDAQ market makers must post de-anonymized buy and sell orders, the two-sided obligation. So they have to actually notate their specific buy or sell orders. That identifies them as the registered market maker behind the orders. Each of the known defendants were NASDAQ registered market makers during the relevant period. So again, they would have to abide by these rules. The two-sided obligation applicable to the known defendants mandates that each be willing to buy and sell security for its own account on a continuous basis during regular market hours. Moreover, every broker-dealer, including the known defendants, is required under NASDAQ rules to engage in a course of dealings for its own account to assist in the maintenance insofar as reasonably practicable or of fair and orderly markets. So again, they're required to participate each day in the market for the different securities that they're representing as market makers. On information and belief based on methodology described in paragraphs 38 through 45, defendants' market activity in Mullen shares was not limited solely to de-anonymized orders placed pursuant to their NASDAQ two-sided obligations. Records produced by the Depository Trust and Clearing Corporation, the DTCC, indicate that the defendants often transacted far more Mullen shares that were evidenced by their de-anonymized orders alone. So that's important as well. Basically, they were doing additional transactions and they were not logged on these two-sided obligation orders. So that's important, and Mullen's going to be able to, or Mullen's attorney is going to be able to show how that is relevant and how these market makers did just that. For example, on the settlement date of July 14th, 2023, reflecting transactions executed on July 12th, 2023. And remember, there's a T+2 period. So whatever, that's the settlement date, whatever transactions were happening on day one, they will be known on day 3. They will actually hit those specific accounts on that day. For example, on the settlement date of July 14th, 2023, reflecting transactions executed on July 12th, 2023, DTCC daily position reports show Clear Street LLC's DTCC closing balance increased from 22,016 the day before to 401,516 shares of Mullen. So that's an increase of 379,500 shares. An increase in Clear Street LLC's DTCC balance on the settlement date of July 14th, 23 indicates that Clear Street purchased shares of mulnstock on the transaction date of July 12th, 2023. So again, Mullen and their attorneys are setting up how they're able to prove that this market maker made a significant number of purchases during this specific trading day, and it was not just provided by these de-anonymized orders. So again, however, NASDAQ's records indicate that none of the de-anonymized orders placed pursuant to Clear Street's two-sided obligations were executed on the trading date of July 12th. So according to NASDAQ, this market maker didn't place any orders. But again, with using the DTCC, you can show that it did. This may be hard to see, but I just wanted to break down some of the footnotes in this specific lawsuit case. So this is actually really important. When I started to read through these, I realized the importance. So I actually kind of jumped through the footnotes instead of just looking at the main filings after I had finished all the filings. So just let's read along. After plaintiffs filed the original complaint in this matter, Clear Street Markets and IMC wrote to the plaintiff claiming that they did not trade any shares of Mullen on a large number of dates listed in the original complaint. IMC's counsel went further and during a meet and confer represented that IMC did not even place a single order for Mullen shares on the days on which spoofing was alleged in the original complaint. For several reasons, plaintiffs do not find these representations credible. This is important because those of you who have been following this lawsuit, you would have seen these specific market makers, the defendants, you would have seen their response where they were basically trying to kind of discredit and disprove, saying, hey, none of this stuff really happened. They provided a very small amount of actual orders that were placed and showed the insignificant amount of money made by them in regards to that. So again, Mullen's attorneys have went back through and they've added this response, and I think it's very powerful, and I think it's very important, and I am optimistic that the judge will see it just like that. So first, these no trading representations by Clear Street Markets and IMC are inconsistent with their obligations under the NASDAQ rules to engage in a course of dealings for its own account to assist in the maintenance insofar as reasonably practicable of a fair and orderly market. So we talked about that already, but again, the attorneys are putting that little bit of information out there. Second, Clear Street Markets claim that Clear Street did not transact in Mullen shares on any of the pricing dates is contradicted by data obtained from the DTCC. We just went over that. As discussed above, a purchase of Mullen shares would not necessarily lead to a change in Clear Street LLC's DTCC balance if purchases and sales offset each other. However, the DTCC data indicates that Clear Street, its subsidiaries, corporate parents, corporate siblings, or affiliates, or its customers purchased Mullen shares on the days identified in the first amended complaint through its own account and or through third parties that ultimately accumulated in clearing transfers to Clear Street. For example, DTCC records for settlement date March 18th, 22, reflecting purchases and sales executed on March 16th, 22, show a net increase of 916,264 shares in Clear Street LLC's closing balance, from a closing balance of 31,835 shares on the settlement date of March 17th, 22. So that's a significant amount of increase of shares that Clear Street LLC was responsible for within a single trading day. And again, this is what the defendants are saying they didn't do anything about, or they weren't participating. Okay, so the date for which the DTCC position report strongly suggests net purchases by Clear Street, March 16th, 22, was a pricing date for sales of shares by Mullen. Similarly, IMC cleared through Goldman Sachs, while other parties also cleared through Goldman Sachs. DTCC records for settlement date March 14th, 23, reflecting purchases and sales executed March 10th, 23, show a net increase of 825,944 shares in Goldman Sachs closing balance, from a closing balance of 24,432,488 shares. Shares on the settlement date of March 13th, 23, to a closing balance of 25,258,432 shares on the settlement date of March 14th, 23. So again, they're showing a single day change. They're showing a net increase of shares in the Goldman Sachs closing balance, and Goldman Sachs is being utilized by IMC. The date for which the DTCC position reports indicate net purchases by Goldman Sachs. March 10th, 23 was a pricing date for sales of shares by Mullen. Third, Clear Street Markets representations concerning its order activity were inconsistent with the NASDAQ data. For example, Clear Street Markets claimed that on October 25th, 22, it maintained a single order to buy 100 shares of Mullen and a single order to sell 100 shares of Mullen at all times for the entire trading day on October 25th, 2022. However, on October 25th, 2022, Clear Street Markets placed over 60 distinct new attributed orders, which did not replace prior orders, message F in publicly available NASDAQ Total View, ITCH, historical data, at prices ranging from 42 cents to 78 cents, or 0.7865 cents. In addition, on that day, Clear Street Markets placed over 48,000 new orders, which replaced prior attributed orders. The aggregate share volume in these cancel replace messages total over 4.9 million shares. So again, if you're a judge and the defendant comes out with false information and the plaintiffs turn around and provide clear evidence to show that what they're saying is not true, it's not looking too good in my opinion. Fourth, IMC's counsel's representation during a meet and confer that IMC did not place any orders for Mullen shares on the pricing dates in the complaint is flatly contradicted by the ITCH data. Finally, neither IMC nor Clear Street Markets provided Mullen with verified records of their own order and trading activity as submitted to the Consolidated Audit Trail pursuant to their regulatory obligations. As evidence of its own activity, Clear Street Market provided a partially redacted screenshot of 2 Excel sheets showing 4 rows of data on 2 days and publicly available ITCH data already in Mullen's possession. In conducting a reasonable inquiry into the factual basis of these allegations, plaintiffs are not required to accept Clear Street Markets and IMC's self-serving, unverified representations that are inconsistent with their legal obligations and the data plaintiffs obtained from third parties. So again, Mullen showing that these specific defendants are giving very little information or publicly available information, and Mullen is able to use the DTCC to actually show, prove by transactions that these volumes, these number of shares were a lot larger than what the defendants are claiming. And getting into the details of some of these transactions, Mullen and the attorneys are trying to show that the baiting orders that were never meant to actually be transacted were very much so utilized in order to drive the price either up or down by the market maker. So if you look at section 39, it says here plaintiffs' claims are based on a far more conservative methodology. So really quick, if you were looking at the lawsuit, you'd see that typically a lot of these spoofing cases are able to use a 5-second window of time in order to validate that it was very much so a baiting type order and that spoofing was going on. What Mullen and the attorneys did is they went a lot more detailed and a lot quicker time periods of transactions, which helps increase the probability that that is what was going on. So again, here the plaintiff's claims are based on far more conservative methodology than the 5-second imputation window, which was found adequate to survive a motion to dismiss in NWO. Instead of 5 seconds, plaintiffs attributed orders set by a NASDAQ market maker only if they were placed within the same nanosecond or millisecond of each other. So that is a very, very small portion of time at which these orders were placed and then removed. Again, if a company is using software such with algorithms and things of that nature, that is how you're able to create such quick baiting type orders. So this highly plausible interference is based on, among other things, the properties of the technology through which order messages are sent to exchanges in computerized packets of data, meaning that a single market participant's close-in-time orders are likely to be part of the same data envelope, with the result being that a market participant's close-in-time orders are submitted at almost the same time to the exchange. So I think that's really important that Mullen and the attorneys are basically utilizing a much more conservative methodology to show that these specific transactions were very much done by the market maker. All right, jumping into section 45, the method imputes the firm identifier from the de-anonymized orders to anonymized orders arriving within the same nanosecond or millisecond, again, based on the expectation that the anonymized and de-anonymized orders are sent by the same market participant at the same time, including cancel replace messages throughout the trading day, which indicate a new order was replacing an old one. And then I highlighted this for importance. And moreover, to ensure that the same order was not included more than once, the methodology took the added precautionary step of removing duplicates that arose during the imputation process, even though doing so could remove accurate imputations and result in spoofers evading liability for their participation in spoofing schemes. So again, Mullen is going, and the attorneys are going much more granular than a 5-second window. They're going into millisecond and nanosecond transactions, as well as removing any duplicates. So if a same baiting order is utilized for the exact same amount of money, it is being taken out of this spoofing case. All right, now we're going to go into the magnitude for this specific suit. So now that you've understood exactly what the spoofing is about and how Mullen and the attorneys are utilizing the market data in order to show the relevance and to show the case for which these market makers would be doing the spoofing, you can see exactly the total magnitude. So defendants, this is section 58, defendants submitted fictitious baiting orders totaling at least 470,931,814 shares on the NASDAQ during the relevant period. So that's the 2-year period. The defendant's baiting orders led to a substantial sell-side imbalance in defendant's order flow, which were intended to and did send false and misleading pricing signals to the marketplace that interfered with Mullen's share price being determined by natural forces of supply and demand. Oh, and this is section 60. Over the course of each spoofing episode, debating orders placed by the known defendant successfully induced the entry of sell orders from other market participants, driving down the price of Mullen shares by an average of 1.09% per episode. So again, between Mullen exercising providing shares for the exercise warrants and also these two new plaintiffs putting in sell orders as well, all of those transactions are being affected by the spoofing. Section 61, almost simultaneously, the known defendants executed existing purchases to purchase a total of 2,777,294 shares at these depressed prices below the prevailing best offer price or best offer prior to entry of debating orders. So again, these market makers, these defendants, are utilizing the spoofing methodology in order to get a reduced price. Going into on the right-hand side, this is part of Section 65. Only after complete and full party and non-party discovery can plaintiffs conduct a full and complete analysis of market activity to determine the extent of or to which the known defendants and John Doe's unlawfully manipulated Mullen share price. So again, this is just the information that Mullen and the attorneys have been able to put together. There is a lot more that if provided in discovery, specifically these John Doe's, this could be even larger of a magnitude case, but this is what Mullen and the attorneys are putting out for the judge to review. I went ahead and highlighted UBS as them being the market maker. They have the largest portion of baiting orders as well as the average price decline. So you can see that during the relevant period, UBS purchased a total of 470 times and had a total amount of baiting orders of 431,034,674. So that is a ridiculous amount of offset between baiting orders and actual purchases. And then the purchase volume during that time period was 689,621 shares. So again, they're utilizing over 430 million baiting orders in order to purchase a total of 689,000 shares over the course of 476 transactions. So just looking at the ratio of baiting orders to purchase volume, it is 625 to 1. And again, it had an average price decline of negative 1.7644%. So again, that is for those specific orders. And as Mullen has and the attorneys have talked earlier on in this filing, and you'll hear later on in the filing, this is not a temporary adjustment to the price. This has more of a permanent result in price action, and you will see how that's tied in later. All right, Section 82 says, as discussed above, defendants participated in spoofing schemes either by placing orders and or executing trades for their own proprietary or principal amounts, or doing so on behalf of customers or clients. Either way, pursuant to applicable industry rules and regulations. And here's how Mullen's attorneys are tying in what's going on with the law. It says, including SEC Rule 15C 3-5 and FINRA Rule 3120 and their own compliance manuals, defendants were gatekeepers of the integrity of the marketplace. Defendants were required to have internal policies, procedures, and systems that monitored, detected, and prevented their own and manipulative or fraudulent trading devices or schemes of their customers. Defendants failed to adequately design compliance systems or maintain supervisory policies and procedures to prevent the spoofing episodes set forth in this first amended complaint. Given defendants' obligation to monitor, detect, and prevent manipulative or fraudulent trading, and their FINRA report 3130, in which they stated they did in fact do so, defendants either intentionally manipulated the market through their spoofing scheme or recklessly ignored their own or their customers' fraudulent trading. So that's a very powerful statement that Mullen's attorneys are making in terms of the defendants and how they are acting outside of the law. And these are the allegations that are set forth against the defendants. And then the next section I want to talk about is Section 83. It says the short time period between the placement and the cancellation of defendants' baiting orders is further indicative of Scienter. And Scienter, for those of you who don't know, in legal terms, it refers to a culpable state of mind. In other words, Scienter is a defendant's knowledge that an act or conduct is wrongful and intent to act despite this knowledge. Scienter is often an element of liability, including in most cases involving assertions of fraud. So again, it's a very powerful word. Those of you who didn't know what it meant, I didn't know either until I had to look it up. If you are a legal buff, you probably already did know that. But again, this is definitely what Mullen is putting in here, and you will see later on that there is a section of claim about fraud. So the short time period between the placement and cancellation of the defendant's baiting orders is further indicative of Scienter. The known defendants placed and then canceled the baiting orders within seconds and even milliseconds. The fastest time to cancellation among spoofing episodes by IMC, UBS, and Clear Street, and you can see the times there was 0.000000822. That was by IMC, and then UBS was 0.000062106, and then again Clear Street, they give that as well at 0.000001181 seconds respectively. This practice, which occurred thousands of times over the relevant period, indicates that the known defendants were never intended to execute the baiting orders. Again, how do they do this? They did this through their proprietary trading software, their algorithms, and everything else of that nature. Section 85, the size of the baiting orders that were canceled in comparison to the size of the bona fide sell side orders that were executed by the known defendants is also indicative of Scienter. During each spoofing episode, the known defendants placed and subsequently canceled a median of 5,700 shares in baiting orders while executing a median of 0 sell side orders. So that's pretty big. That's showing that these three defendants had placed volumes of baiting orders and had 0 actual executing sales. So why would they be making these if they didn't have any intention of actually offering these on the market? Because this is part of this baiting and the spoofing that we've been talking about. All right, jumping ahead to section 90, I went ahead and highlighted and underlined some pretty important parts. Just wanted to kind of talk through this. Defendants had a strong motive to spoof shares of Mullen stock by posting the fictitious baiting orders. Defendants were able to purchase millions of Mullen shares at depressed prices compared to purchasing shares of Mullen at the prevailing best offer. In some cases, as described below, the known defendants executing purchases closed out a pre-existing short position, yielding an immediate profit. In other cases, known defendants converted these profits to cash by selling shares prior to the price decline or following a partial rebound. So again, the allegations is that these defendants were manipulating the share price using these baiting orders to not only gain money in terms of their short position and be able to close those out, but also to be able to cash out specific sales or purchases at a lower, partially deflated position or share price. Going a little bit further, they provide an example that the SEC took. So section 91, while the profits from any single spoofing episode are small, the rapid placement and cancellation of these baiting orders by known defendants shows how the accumulation of profits due to spoofing activity may be substantial. Because rapid placement and cancellation allows the strategy to be repeated over and over and applied to numerous securities on an industry or even market-wide basis. And then here it is. In SEC versus Lex Securities, a case which involved a common form of spoofing known as layering, the SEC wrote in its complaint that although the defendant's profit on any single instance of layering might have been small, when multiplied by hundreds of thousands of instances of layering in which the defendant capitalized this section, I didn't put the rest of it here, but basically this is giving an example from the SEC in terms of this specific securities entity, that although these individual ones didn't amount up to a lot, over time in combination it would become substantial. So jumping on to section 100, Clear Street had a motive to engage in spoofing in order to close a short position. So we already talked a little bit about one of these other defendants, but this is actually going into more the defendants in general. This one's going into more detail. So Clear Street had a motive of engaging in spoofing to close out a short position of Mullen stock, and they gave an exact example on March 8th, 2023, and they gave the exact time up to the, looks like a millisecond, nanosecond. Clear Street sold 100 shares of Mullen stock at a stock price of 0.1953 per share, yielding a return of 3.224101% by executing purchases at artificially depressed price of 0.1892. So again, this is an example of how they were manipulating or allegedly manipulating the stock price in order to be able to close out their short positions. While the dollar profits on that single transaction were small, the profits from spoofing activity are far larger when performed repeatedly and compounded through Clear Street's algorithms that operate in thousands of securities. On an annualized basis, the return of this spoofing episode is extremely significant. Achieving that return every day over 1 year would have multiplied Clear Street's capital invested in spoofing episodes more than 8-fold over the course of the year. So this is how Mullen is tying the magnitude of what's going on to this one specific episode. All right, jumping to section 138, we had already talked about Clearstreet. Now we're going to talk about UBS. So UBS had a motive to engage in spoofing in order to close their short position in shares of Mullen stock. On August 23rd, 2023, they give the exact time, UBS sold 200 shares of Mullen stock price at 0.8469 per share, yielding a return of 2.159228 by executing purchases at the artificially depressed price of 0.829 per share. So again, this is an example that Mullen is providing of how this defendant is utilizing the baiting orders and this, spoofing methodology to be able to close out a short position. While the dollar profits on this single transaction were small, the profits from spoofing activity are far larger when performed repeatedly and compounded through UBS's algorithms that operated in thousands of securities. So this is the exact same thing they're talking about with Clearstreet. For this instance, they went ahead and extrapolated over the course of a year, and for them, they would have more than 5-fold over the course of the year in terms of return. Jumping into section 157. So this is where Mullen starts to talk about how these spoofing episodes affected other entities, company, or individuals. So defendant spoofing caused plaintiffs to suffer significant losses. So during the relevant period, Mullen sold or issued for value over 5 billion Mullen shares. We know that these shares were added into the market in terms of warrants being exercised. However, if the prices were temporarily, artificially depressed, that would have a significant impact as these shares were exercised and put into the market. As set forth below, many of the known defendant spoofing episodes occurred immediately prior to plaintiff's sales or issuances. So this is what I was talking about in terms of warrants. Because plaintiffs sold or issued for value Mullen shares during the relevant period, at times when the prices of those shares were artificially deflated due to defendant spoofing, plaintiffs were directly damaged by defendants' unlawful conduct. So if you remember, Mullen shared in their 10K, or I'm sorry, their 10Q, their annual return, 10K, that they had a realized loss of over $1 billion in terms of some of the security transactions. And this is a portion of that. Yes, they did sell their securities to various lenders. However, the price of the shares did go down over time, and this spoofing episode did play a factor into that. So that's what Mullen is tying in right now. So jumping down to 158, each spoofing episode was intended to and had a significant immediate impact on the price of Mullen shares. The after effects of each spoofing episode could be felt most strongly within 1 minute of the cancellation of the baiting orders, with a significant and observable effect persisting for hours and lingering for multiple days. So again, this played a significant part in Mullen's share price decline for specific timing of each of these episodes. And you'll see in just a few more slides how this correlates to long-term impact. And in terms of the long-term impact, here we go. Section 161. This effect, the persistence of the price impact of manipulation, is well established in the market microstructure literature. As Nobel Prize winning economist Professor Milgram has explained, because manipulative trades are viewed by the market participants as potentially informed, and potentially informed trades can result in permanent price impact, manipulative trades can lead to permanent price impact. So there you go. So this basically correlates, this professor correlates that these episodes will have permanent price impact to these different companies, to the stock. Based on excessive review of applicable literature, Dr. Milgram provides 2 reasons for why the market participants cannot readily identify manipulative trades. So the first reason is highly improbable that manipulative trades can immediately be identified as manipulative and uninformed by the market participants. For any agent in the market, the incentive to gather private information and thus become informed is directly related to the volume of its trades and of its position. So that's important to kind of show. It's very difficult to be able to prove that these were manipulative. However, Mullen has put together the case using the DTCC information as well as the NASDAQ transactions, and then what the small amount of information that these defendants have provided. They've been able to tie all this together to kind of show how these spoofing episodes were created and then what the impact was. Jumping into section 168, Professor Milgram discusses the extensive economic literature establishing that the price impact of any form of trade-based manipulation, including spoofing, is not likely to fully reverse, meaning it's going to be a permanent impact. Peer-reviewed research has found that order cancellations drive the price up by less than new orders drive the price down. So again, when it comes to bait orders, anytime that you have a baiting order which is less than the best offer at the time, it has a much larger impact than having a baiting order with the price going up. For this reason, the impact of baiting orders is not likely to dissipate merely because those orders were subsequently canceled. Manipulative spoofing causes the execution of trades, not only the placement of orders, because baiting orders induce other market participants to sell shares at artificially depressed transaction prices. So again, whenever market participants, whether they be shareholders, whether they be institutions, when they start to see the bid price going down, whether they have limit orders or whether they have specific types of price points that they're looking at, when these bait orders do show up, they have some of these companies, some of these institutions, they use their own set of algorithms in order to do these trades, and they're going to automatically get out when they see these depressed pricing. So going into 169, the permanent price impact that Professor Milgram discussed as resulting from manipulative trading is established in the economic literature and is not limited to same-day effects. So again, this does have a lasting impact. So we talked exactly how the spoofing episodes were done, how Mullen was able to tie the three defendants to their transactions, in terms of the baiting orders versus the executed orders, how those companies were making some profits. We talked about how the short-term impacts of these spoofing episodes, and then we talked about how there is a permanent impact according to the Milgram report. And if you want to hear more about the Milgram report, it is Exhibit 5. And I can share that if you guys would prefer. Just shoot me a comment and I'll break that down as well in a later video. But going into the injury, in fact, and loss causation. So this is where they're talking about how the different plaintiffs are being affected. So section 170, as set forth more fully herein, defendants' fraudulent trading activities have both temporary and long-term adverse effects on the market price of Mullen securities. 171, during the relevant period, the spoofing events identified by the manipulation analysis occurred on 359 out of 504 trading days, which is 71% of the trading days within this specific period, the relevant period. Based on records maintained by shareholder plaintiffs, the shareholder plaintiffs sold various amount of shares during the relevant period. So again, this is showing the price action for Mullen as a company and how they were exercising shares for these warrants. Based on records maintained by Mullen, over 5 billion shares were sold or issued for value by Mullen during the relevant period. Many of these sales consisted of issuance of shares to satisfy debt obligations. So these are the SPAs, the warrants, or other liabilities where the price of the shares was formulaically, we're just going to leave it like that, derived from secondary market closing prices on one or more days on which, as indicated by manipulation analysis, those prices were artificially depressed by defendants' manipulative spoofing. So again, this is how Mullen, a company, this is how they were affected in terms of their money, and then how the share price was affected. Section 174, we'll just talk a little bit about pricing formulas. They can divide into two groups. First group consists of sales of common stock, which occurred at closing price of one or more pricing dates. So these would be the ones that the various shareholders, market participants would have been exercising in terms of common shares. And then the second group is the issuance of shares to satisfy debt obligations. So these would be the warrants. So both of those have impact. And yes, the exercise of warrants, adding additional shares to the common share count, will have some impact, but when you couple that with the spoofing episodes, it has a larger impact, as well as market participants selling their shares at these temporarily deflated pricing points. Jumping into the next section there, talked about the liabilities. So these liabilities are both cashless warrant exercises, where the value of the liability is extinguished by the sale of shares was based on the closing price of one or more pricing dates on which those prices were artificially depressed by defendants' manipulative spoofing. So again, we talked about the derivative liabilities on the Mullen 10K, and this is what drove some of that impact. Collectively, the dates for which the closing prices were used to, there's that word again, formulaically, there you go, derive the value of the sale or issuance are the pricing dates. So then it talks about the different exhibits. So exhibit 2 would be the sale of Mullen shares or issuance for value by Mullen, the company, at prices artificially depressed by the defendant's spoofing activity. They talk about the different spoofing episodes by each known defendant, and that they were occurred on the designated pricing date, thereby depressing the price of Mullen shares sold or issued by Mullen on the indicated transaction date, which was executed at the closing price of Mullen shares on the pricing date. So again, Exhibit 2, if you were to look through that, it's just a list of all the transactions from Mullen in terms of whether they be providing debt obligations in terms of new shares, adding to the common share count, or any of their actual purchase of shares themselves, because you remember they did have a share buyback program going on. Exhibit 3, this is section 176, this talks about the sales by plaintiff Cheyenne Korami. This plaintiff sold Mullen shares on open market in close proximity times when the known defendants participated in the spoofing schemes. And they gave examples of this. August 3rd, 2023, the plaintiff sold 100,000 shares of mulnstock mere minutes after Clear Street engaged in the spoofing episode on that same day. Similarly, on June 15th, this plaintiff sold 25,243 shares of mulnstock less than 2 hours after UBS engaged in spoofing episodes on that same day. And then Exhibit 4 is another plaintiff. This is Hyan Cha. Plaintiff Hyan Cha sold Mullen shares on the open market in close proximity to the times when known defendants participated in spoofing schemes. And then they gave an example of that. Jumping ahead to 178, defendants' fraudulent trading activities had both temporary and long-term adverse effects on the market price of Mullen shares. As discussed above, the artificially depressed price resulting from any given spoofing episode does not fully recover to the price that existed prior to the spoofing episode. And when spoofing events occur continuously throughout the day and continue without interruption over a protracted period of time, the long-term cumulative effect of spoofing places enormous downward pressure on the market price of a security, which is persistent and long-lasting. So if you remember, Mullen's attorneys they had the naked shorting case open, and then they had the spoofing case open. They said that the spoofing case would have a much larger and much more higher magnitude in terms of the impact for the share price of Mullen, and we're starting to understand a little bit more by understanding how the spoofing episodes were transacted and how Mullen, the company's stock, was impacted, as well as these two plaintiffs. Section 179, the priced impact of defendants' spoofing activity was not limited to the time period immediately following each individual spoofing episode. As a result, plaintiffs and Mullen shares and issuance for value of its stock throughout the relevant period were negatively affected by the defendant's spoofing that occurred in close proximity to those sales and issuance by the lingering price impact of spoofing episodes. So again, they're just laying out that the spoofing episodes had a significant impact on the company's transaction of shares. While each spoofing episode had a small negative impact on the price of Mullen shares, the placement and cancellation of baiting orders throughout the relevant period had a cumulative effect of driving Mullen share price down during the relevant period. According to manipulation analysis, defendants' wrongful conduct proximately caused the losses that Mullen suffered when it sold or issued for value shares at times during the market price of Mullen shares was being driven downward, or was driven downward by the lingering effect of past spoofing episodes. Plaintiffs suffered when they sold Mullen shares at times during which the market price of Mullen shares was driven downward. 181, defendant spoofing had a persistent and long-lasting price impact on the share price of Mullen, even when adjusted for market-wide price movement. So this is going to actually tie in the NASDAQ and look at that versus Mullen. The following graph shows the average cumulative return across spoofing episodes identified by manipulation analysis from 30 minutes prior to each executing purchase to the end of the trading day. The red line shows Mullen's return, while the blue line shows, for comparison, the return of the NASDAQ Composite Index. The dashed line shows the final cumulative return over the minutes following spoofing episodes, indicated by manipulation analysis. So you can see that the spoofing episodes had a negative impact of 3.35%, which is highly statistically significant when looking at a standard t-test. So you can see from the top the line that pretty much stays very close to 0%. That would be the NASDAQ Composite Index. Whereas Mullen, if you look, they were following the NASDAQ Composite Index rather closely until the spoofing episode happened. And you can see that the big pull down there, about 1.5%. And then over time, throughout the rest of the trading day, you can see how that price impacted. All right, we're getting close to the end, folks, so bear with me. Just a couple more slides left to go. Section 183, moreover, to whatever extent confounding information that negatively impacted the price of Mullen may have emerged at around the same time as the known defendant spoofing episodes, it is exceedingly unlikely and implausible that the confounding information emerged at precisely the same time as so many of these spoofing episodes repeatedly, so as to confound the average price impact of these episodes. This is all the more convincing when considering that each spoofing episode occurred at points in time that are quasi-random, meaning they're unlikely to be systematically correlated with confounding information such as negative news releases. So this is basically tying in that these spoofing episodes did not have anything to do with any of the news that Mullen was providing, whether it be positive or negative news, that these specific episodes were merely the cause of these baiting orders. This strengthens the inference that the decline in the share price of mulnstock was caused by the defendant's participation in spoofing schemes. So pretty much just negates the fact that the defendant may try to say, oh, well, Mullen put out some bad news, had some bad PR. That was actually the reason for the price decline. No, they were saying that these spoofing episodes were random and did not have any correlation to do with Mullen's news. Section 184. Second, the fact that there is no material or statistically significant price declines in the minutes leading up to the spoofing episodes, and we talked about that on the previous graph, strengthens the interpretation that the decline in the price at the time was caused by those episodes. It is standard practice in the economic literature to examine the presence or absence of so-called pre-trends. Again, pre-trend would be prior to something happening, and you can see that pre-trend was correlating with the NASDAQ, which might indicate that a purported causal effect was contaminated by a spurious event that was occurring prior to the intervention of interest. So again, part of the literature, you have to make sure that this is not a cause. And according to this report here, you can see that the PR was not at all involved with the spoofing cases. You can see that the price of Mullen stock was trending well within the NASDAQ Composite Index. Section 187. Moreover, these price declines accompanying the spoofing episodes are unlikely to have been caused by any dilution accompanying the issuance of shares by Mullen. So I know a lot of people have been very frustrated. They're saying that the share price has been just dragged down due to dilution. But what they're showing here is that outside of any forms of dilution, these spoofing episodes had a major impact to the price. To the extent any dilution negatively affected the price of Mullen shares, that would have occurred through the additional sale of newly issued shares. However, the spoofing episodes occurred at short, discrete intervals in time. There's no reason to believe, nor has Mullen identified any evidence to consider that purchases of newly issued shares were aware of spoofing episodes. Basically meaning that these lenders that were exercising warrants, they were not aware of these spoofing episodes and were trying to sell prior to that occurrence or during that occurrence. Much less that those shares were likely to be sold during these short, discrete intervals in time. Sorry, I just read that. It is extremely unlikely as a statistical matter that any such sales occurred systematically within narrow 2-minute windows of time. The sharp decline in price of Mullen shares in those very minutes indicates that dilution was not responsible for that decline, because any such price impact to dilution would have naturally occurred over the course of time as newly issued shares were sold into the market, meaning Mullen's just not dumping millions of shares within a millisecond. The spoofing episode happened within a short period of time. You could see a massive, or you could see a large, I should say, price decline in percentage. All right, we've tied the spoofing. We've talked about how it had nothing to do with Mullen's PR, how they're showing that it was not at all impacted due to the dilution because of the timing of it. So now we're going to talk about the claims for relief. So the first claim for relief for spoofing in violation of Section 10B of the Exchange Act 1934 and Rule 10B 5A and C promulgated thereunder. Plaintiffs incorporate by reference paragraphs 1 through 192 as if fully set forth herein. So basically, they laid it all out, and then now here's what they're asking for. During the relevant period, the manipulation analysis indicates that defendants participated in a scheme that was intended to and did manipulate the price of Mullen shares by placing baiting orders on NASDAQ. Defendants' baiting orders were used to further a market manipulation scheme that had a direct and immediate adverse impact on the market price of Mullen securities being traded on NASDAQ. And they talk about rules 10b, 5a, and c, make it unlawful for any party to employ any device, scheme, or artifice to defraud and to engage in any act, practice, or course of business which operates or would operate as fraud or deceit. So basically, this specific portion of the law says you cannot do anything that you know is illegal, that is deceitful, which is where that word Scienter gets put in place. So the manipulation analysis indicates that defendants are liable for placing baiting orders on NASDAQ that had no legitimate or economic purpose, were never intended to be executed, and were part of a spoofing scheme. Placing executing orders that were intended to complete the spoofing episode that operated as a scheme to manipulate the market price of Mullen securities. Second claim. This is spoofing in violation of Section 9A2 of the Securities Exchange of 1934. Plaintiffs incorporate by reference paragraphs 1 through 204 as it's fully set forth herein. The manipulation analysis indicates that defendants' manipulative schemes violated Section 9A2 of the Securities Exchange Act of 1934, which makes it unlawful to engage in a series of manipulative transactions in any security, creating actual or apparent active trading in such security, or raising or depressing the price of such security for the purpose of inducing the purchase or sale of such security by others. So you can't manipulate the stock price in order to be able to make a transaction, in order to make a sale. So we already talked about how they closed out their short position. We talked about how they made some profit in terms of after these spoofing episodes occurred. All right, and this is the last slide of the lawsuit document that I'm sharing with you all. So thanks for bearing with me. Let's go ahead and get into this last little bit. So third claim for relief is for New York common law fraud. So this is why I mentioned that they were talking about fraudulent activities. Plaintiffs incorporated in reference, and again, they're going to talk about all the paragraphs used in this specific lawsuit document, this filing, 1 to 210, set forth herein. Plaintiffs seek to permanently enjoin defendants from engaging in spoofing conduct, whether on their behalf or on behalf of their customers, that affects the Mullen share price. This is huge. If successful, they're not going to be able to spoof any more of Mullen shares. And this is going to set a precedent for any future market makers that may want to try and attempt to do the same thing. Defendants' actions identified herein have caused, continue to cause, and will cause future permanent and irreparable harm to Mullen. Plaintiffs Hyan Cha and Cheyenne Korami presently own shares of mulnstock and thus still are and will continue to be harmed by the defendant's spoofing conduct. So they're putting it all out there like, you guys need to stop them from doing this moving forward. The balance of the equities favors an injunction to prevent defendants from continuing to spoof shares of Mullen stock. The harm to plaintiffs is significant. In contrast, the potential harm to defendants of an injunction is insignificant, meaning it shouldn't hurt them to be forced to stop spoofing. It's not legal. They just went over all that. They provided the law, the Securities Exchange Act law that says you can't do this types of stuff. So the market maker should still be able to act as gatekeeper and do their job, regardless if they are being told by the attorney, or I'm sorry, being told by the judge, you can't do this anymore. Defendants would merely be required to halt their illegal activity. Thus, the public interest is best served by enjoining defendants' spoofing behavior. As noted throughout this first amended complaint, it is likely that the plaintiffs will succeed on the merits in this case. That is a very, very bold statement. It's a very confident statement that Mullen and the attorneys have. They're basically telling the judge, with all this information provided in paragraphs 1 through 210, we feel that this succeeds. This will sorry, that this is likely that the plaintiffs will succeed on the merits of this case. They laid it all out there. They provided all the steps. They provided transactions. They explained in detail on how this has long-term permanent impacts to the company's share price, and how the company, as well as these other two plaintiffs, how they were injured, or they're from a pricing standpoint, from a capital standpoint, because of this. So prayer for relief. This is what Mullen and their attorneys are asking for. Wherefore, plaintiffs respectively request that this court enter a judgment finding that defendants violated the federal security laws as alleged in the first amended complaint, ordering defendants to pay damages as a result of their unlawful conduct in an amount to be determined at trial. So this is going to be huge. If the judge agrees and moves forward with trial, the amount of damages, I'm assuming Mullen is going to be putting out another filing to kind of put into place how much, what kind of impact this is going to be financially. Enjoining defendants from engaging in any further manipulation of the share price of Mullen, whether on their behalf or their customers' behalf. This should be a no-brainer. Awarding reasonable attorney fees and costs together with all available pre- and post-judgment interest. Again, the defendant should be paying for the plaintiff's legal fees. The company's stock price should not be affected by that. And the last section here, the plaintiffs are demanding a jury trial. Pursuant to Rule 38 of the Federal Rules of Civil Procedure, plaintiffs demand trial by jury in this action of all issues so triable. Well, thank you so much for sticking around through the end of this and for reviewing this lawsuit filing with me. If you like what you heard, please consider liking this video. Subscribe if you haven't already. If you'd like to hear more content about Mullen, leave me a comment. Let me know what kind of information you'd like to hear about. And I will see you guys on the next one. Thanks.